Good day everyone, I am Danica Magallanes and I'm here to discuss about the last chapter of our module. So we have the institutional based correction, the structure, management, the standard, the program and services here in the Philippines, two system-based approaches to correction, the Bureau of Correction, RA 10575, their custody, security, and control of prisoner, the care and treatments of prisoner, release of prisoner, the conduct time allowance or the GCTA, prohibited acts subjects to this disciplinary action, the BJMP Republic Act 6975, the Republic Act 9263, the treatment of special needs or unusual offenders, the emergency plans, the movement, transfer of prisoner, detainees, and privileges of detainees and sentenced prisoner. And also we have the regional rehabilitation centers for youth, the child and youth welfare code, the death row, and the rule of right of amparo. So let us start with the code. It is during our darkest moment that we must focus to see the light by Aristotle Onassis. So what could be the meaning of these quotes? For me, when things are going well, anyone may be joyful, optimistic, and appreciative, but when nothing is going right, we genuinely need to focus in order to perceive the light. That is when we need to dig deeper into thankfulness and focus on the positive aspect of our lives. Everyone has felt surrounded by darkness at some point in their lives. The fact is that there is still hope. We must recall how to view it when the darkness threatens to swallow up us. We have to see it more clearly and focus on it. The light in the darkness is always present and waiting for us. It might be difficult to notice, attain, and maintain. The actual trick to be self-sufficient when you need it the most. It is our darkest moment that we must believe in ourselves without giving up hope. Every great thing is born from failure. Those who persevere, in the face of adversity are more likely to attain excellence. Never give up and keep trying until you succeed. So, first, the Philippines correction system. So, the Philippine correction system is made of the institution from the government, civil society, and the private sector that are involved in the incarceration, correction, and restoration of those accused with or in convicted of delinquent act or crime. So the government develop appropriate policies and procedures for corrections, the penology and the jail management, as well as the rehabilitation and restoration. The government has direct management and oversight over all prisons or penitentiaries, jails, and detention centers. So first we have the structure, management, standard, program, and services in the Philippines. So first, the structure. The Philippines correction system is composed of the institutions in the government and civil society and the business sector which are involved with the confinement, the restoration, the correction, and of those individuals charged for the conviction or of delinquent acts or crime. So despite prison overpopulation, a lack of information technology system and knowledge and inadequate training, the Philippine government continues to make meaningful measures toward improving prison and jail facilities and offender treatment. However, the correction system reform and convicts' effective reintegration into mainstream society are not just the duty of the correction system. They require the support of the participation of whole society. And the corrections and rehabilitation of criminals, the government plays a dominating and vital role. Next, we have the management. To limit the length of incarceration, the Philippines also uses absolute pardons, conditional pardons, the computations of sentences, amnesty, the parole, and the good conduct allowances. So the regulations of correctional facilities are intended to allow convicts to form personal and social relationships. Control over the nation's jail has improved because to a consolidated jail system. Special programs and for residential institution after the assistance for youth development and special needs youth. So the several task forces and committees have advocated improvement such as the creation of a national agency to oversee all penal facilities, a more liberal system of release on recognizance, and the legalizations of the victimless crimes standard. So the Philippines follows the requirements of the United Nations Standard Minimum Rules for the treatment of prisoners and the UN Standard Minimum Rules for non-custodial measures, as well as other international human rights agreements that define and protect inmates' rights. So some of these clauses are already included in the Philippines Constitution as well as its laws, also in rules, regulation, and the ordinances. Furthermore, Section 2 of the Constitution states that the Philippines follow broadly accepted international law concept. So next we have the program and services in the Philippines. In Republic Act No. number 10575, the Section 4, the mandates for the Bureau of Correction. The Bureau shall be in charge of safekeeping and instituting the reformation program to national inmates sentenced to more than 3 years. So the safekeeping of national inmates shall include the decent provision of quarters, the foods, water, and clothing, and the compliance with the established United Nations standards. So the security of the inmate shall be undertaken by the custodial force consisting of correction officer with a ranking system and a salary grade similar to its counterpart in a BGMP. So the reformation of national inmates, which they have the reformation program which will be instituted by the Bureau for the inmates shall be the following. So first we have the moral and spiritual program. Second is the education and training program. Third, the work and livelihood program. Fourth, sport and recreation program. Fifth is the health and welfare program, and the last is the behavior modification program to include the therapeutic community. So in moral and spiritual program, this refers to the moral and spiritual values formation of inmate which shall be institutionalized by the Directorate of Moral and Spiritual Welfare DMSW, which include the practice of one's religion and beliefs, participating religious volunteer organization, the RVO, and the individual shall be regulated and managed by the MSW. Next, we have the education training program. This refers to the administration of formal and non-formal education and skill development of inmates which shall be institutionalized by the Directorate for Education and Training (DAT). Participating volunteer teachers, the professors, instructors, and trainers shall be regulated and managed by DAT. So next we have the Work and Livelihood Program. This refers to the administration of skills development program on work and livelihood to achieve self-sufficiency of inmates in the present community and for the income generation by of the agency. This shall be institutionalized by the Directorate of Work and Livelihood (DWL), the volunteer participating agency, non-government organization, and the individual shall be regulated and managed by DWL. Next, we have the Sports and Recreation Program. So this refers to the administration of physical and the recreational engagement to achieve mental alertness and physical ability in the spirit of sportsmanship. So this shall be institutionalized by the Directorate for Sport and Recreation (DSR). Volunteer participating agency, the non-government organization, and the individual shall be regulated and managed by the DSR. Next, we have the Health and Welfare Program. This refers to the administration of proper nutrition, hygiene, sanitation, cleanliness, and the promotion of good health to inmates. So this also includes the provisions of medical care or hospitalization of the sick, mentally impaired, old age, and disabled inmates. This shall be institutionalized by the Directorate for Health and Welfare Services (DHWS), a volunteer participating agency, non-government organizations, and individuals shall be regulated and managed by DHWS. So we have the last one, the Behavior Modification Program. This also refers to the administration of program for the character formation of an inmate necessary for effective interpersonal relation in the prison community. This program also includes therapeutic community. This shall be institutionalized by the Directorate for Behavior Modification (DBM), the volunteer participating agency, the non-government organization, and the individual shall be regulated and managed by DBM. So the core objectives in the administration of this circumferential reformation program is the effective treatment of antisocial behavior and destructive personality disorder of an inmate. So next we have the two system-based approaches in correction. So the person is held in secure correctional institution after being placed in prison or jail. So that could be the the institution-based approach, and the community-based approach is seek to put convicts in the community as they complete their sentences. This program typically enable criminals to work or attend school while incarcerated, and you are either placed on parole or given probation. So there are three departments of the executive branch of the government, the Philippine correction system. So it's presented describing the rule of previous government agency. So we have the Department of the Department of Justice, the Department of Interior and Local Government, and the last is the Department of Social Welfare and Development. So in Department of Justice, they take care of the national prisoners. So the national prisons and penal farm are supervised and administered by the Bureau of Correction, the BUCOR, which is led by civilian director. The Bureau of Correction is tasked with rehabilitating national prisoner so that they can become useful members of the society upon completion of their sentence. So these are the prisoners whose sentence range from 3 years and 1 day to life imprisonment, as well as those convicted of the death penalty or the fine more than 5,000 pesos, regardless of the length of the sentence, for violating customs law or other law under the jurisdiction of the Bureau of Customs, or for violating immigration and elections laws. So, or to one sentence to serve to more sentence to total of which exceed 3 years. So national prisoners are also referred to under the law as the insular prisoners. So we have the Department of Interior and Local Government. So they take care of the municipal, city, and district jails. So the provincial jails is sub-provincial jails are operated by the provincial local government unit under the supervision and management by the respective governors in each province, and those penalty ranges from 6 months and 1 day up to 3 years. So the local jails, namely the municipal jail city and the district jail, are under the supervision and administration of the Bureau of Jail Management and Penology, the BJMP, and those penalty ranges from 1 to 6 months for municipal jail inmates and for city. So inmates whose penalty ranges from 1 day to 3 years. So the district jail may be created turret and monthly jail population is less than 10 inmates. So the third is the Department of Social Welfare and Development. They take care of the sentenced youth offenders, which are located in the DSWD said there are 15 RRCYs across the country. So RRCY is a residential facility that provides intensive treatment for the rehabilitation of male CICLs whose sentences have been suspended. It serves as a nurturing out of home placement to enhance their psychological, emotional, and psychological well-being. So next we have the Bureau of Correction, Republic Act 10575. And Section 1, short title, this act shall be known as the Bureau of Correction Act of 2013. Section 2, the Declaration of Policy. It is the policy of state to promote the general welfare and safeguard the basic rights of every prisoner incarcerated in our national penitentiary. It also recognizes the responsibility of the state to strengthen government capability aimed toward the institutionalization of highly efficient and competent correctional services. Toward this end, the state shall be provide for the modernization, the professionalization, and the restructuring the Bureau of Correction, the BUCOR, by upgrading its facilities, increasing the number of its personnel, upgrading the level of qualifications of their personnel, and standardizing their base pay, retirement, and other benefits, making it at par with the Bureau of Jail Management and the Penology, the BJMP. And Section 3, the definition of terms, safekeeping, which is custodial component of BUCOR present correction system. It shall refers to the act that ensures the public, including the families of inmates and their victims, that national inmates are provided with their basic needs completely incapacitated from the further committing criminal acts and have been totally cut off from their criminal networks or contact in the free society. While serving sentence inside the premises of the National Penitentiary, this act also includes the protection against illegal organized armed groups which have the capacity of launching an attack on any prison camp of the National Penitentiary to rescue their convicted comrade or to forcibly amass firearms issued to prison guards. So next we have the reformations, which is rehabilitation component of the Buchar's present correction system. Shall refers to the act which ensure the public, including families and inmates and their victims, that release of the national inmates are no longer harmful to the community by becoming reformed individuals prepared to live a normal and productive life upon reintegration to the mainstream society. The section 4 for the mandates of the Bureau of Correction. The Bureau shall be in charge of safekeeping and instituting reformation program to national inmate sentenced to more than 3 years. So we have the safekeeping of the national inmates. So the safekeeping of inmates shall include the decent provision of quarters. We have the food, water, and clothing and compliance with established United Nations standards. So the security of the inmate shall be undertaken by the custodial force consisting of corrections officer with a ranking system and salary grades similar to its counterpart in the BJMP. So the section 4, the mandates of the Bureau of Correction. So the reformation inmates, which is be instituted by the Bureau for the inmates, shall be the following. So we have the moral and spiritual program, the education and training program, the work and livelihood program, the sport and recreation program, the health and welfare program, and the behavior modification program, and include the therapeutic community. So the reformation program shall be undertaken by professional reformation personnel consisting of correction technical officer with ranking system and salary grades similar to the correction officers. So the corrections technical officer are personnel employed in the implementation of reformation program and those personnel whose nature of work requires proximate or direct contact with inmates. So the correction technical officers include priests, evangelists, pastors, teachers, instructors, professors, vocational placement officers, librarians, the guidance counselors, the physician, nurses, medical technologists, the pharmacists, dentists, therapists, psychologists, psychiatrists, the sociologists, social workers, engineer, electrician, agriculturists, the veterinarians, lawyers, and the similar professional skills relevant to the implementations of the inmate reformation program. In the Section 5 operation of the Bureau Corrections, the Bureau shall operate with a directorial structure. It shall undertake reception of the inmate through its Directorate for Receptions and Diagnostic (DRD), formerly Reception and Diagnostic Center, provide basic needs and security through its Security and Operation Directorate. So the administrative reformation programs through through its reformation directorates and prepare inmates for the reintegration to mainstream society through its Directorate for External Relation, DER, formerly External Relation Division. So, the DRD shall be responsible for the conduct of classifications of each and every inmates admitted to the Bucor. So the inmate shall be classified according to the security risk and sentence, including in the classification determining the inmate's certain skills or talent, the physical, spiritual, social, mental, and psychological evaluation and other behavioral assessment as reference of the DRD and the preparation of individual inmate reformation programs. So aside from those point of the provision under Rule 8, Part 1, Rules of General Application of the United Nations Standard Minimum Rules for the Treatment of Prisoner, and that of the existing regulation of Bucor on security classification, maximum, minimum, and medium security risk. So, inmates shall be also be internally classified by the DRD and segregated according to crimes committed based on the related penal code, such as crimes against person, crimes against properties, crimes against chastity, so on and so forth, as well as by other related special law, customs, and immigration laws. So we have from the DRD, the custodial force and reformation personnel of respective security institutions camp shall be in charge for the security and the implementation of recommended inmates. So the reformation program of each and every inmate while serving sentence respectively. So the Directorate for External Relation DER shall be responsible for the pre-release and post-release program of inmates due for release. The DER shall be also classify inmates according to skills acquired for referral and endorsement to appropriate companies or corporation participating in the Bucor on the job training program for newly reformed inmates. So the Directorate for External Relation DER shall be also evaluate, classify, and apply necessary programs to inmate for readiness to join the mainstream society upon release. So the part of handling inmates, the Bucor shall be administratively operate like standard government agency through its administrative directorates with internal control and internal audit units. The Bucor shall employ full computerization and the build-up, the maintenance, and transmittal of necessary inmate records to all its prison and penal farms and other recipient agency such as Board of Pardon and Parole. So next, we have the GCTA, Good Conduct Time Allowances. To the Section 5, Article 99 of the same Act is hereby further amended to read as follows. Article 99. Who grants time allowances? So, whenever lawfully justified, the Director of the Bureau of Correction, the Chief of the Bureau of Jail Management and Penology, and or the Warden of a provincial, district, municipal, or city jail shall grant allowances for good conduct, such as allowances once granted shall not be revoked. So Republic Act No. 10592, Section 3, Article 29 of the Act 3815 as amended, otherwise known as the Revised Penal Code, is hereby further amended to read as follows. So the the Article 97 allowance for a good conduct. The good conduct of any offender qualified for credit for prevention and preventive imprisonment pursuant to the Article 29 of this code, or of any convicted prisoner is any personal institutions, rehabilitation or detention center, or any other local jail shall entitle him to the following deduction from the period of his sentence. We have here the program and services. So during the first 2 years of imprisonment, he shall be allowed a deduction of 20 days for each month of good behavior during detention. During the 3rd to 5th year, inclusive of his imprisonment, he shall be allowed a reduction of 23 days for each month of good behavior during detention. So, during the following years until 10 years, inclusive of his imprisonment, he shall be allowed a deduction of 25 days for each month of good behavior during detention. And during the 11th and successive years of his imprisonment, he shall be allowed a deduction of 30 days for each month of good behavior during detention. And at any time during the period of imprisonment, he shall be allowed another deduction of 15 days in addition to numbers of 1 to 4 hereof. So for each month of study, teaching or mentoring service time rendered, as an appeal by the accused shall not deprive him of entitlement to the above allowances for good conduct. Section 4 of Article 98 of the same Act is hereby further amended to read as follows. So, the Article 98 Special Time Allowances for Loyalty. A deduction of fifth of the period of his sentence shall be granted to any prisoners who, having invaded his preventive imprisonment or the service of his sentence under the circumstances mentioned in Article 158 of this code, give himself up to authorities within 48 hours following the proclamation announcing and passing away of the calamity or catastrophe referred in said article. So, a deduction of 2/5 of the period of his sentence shall be granted in case said prisoner choose to stay in the place of his confinement, notwithstanding the existence of calamity or catastrophe enumerated in Article 148 of this code. The article shall apply to any prisoner whether undergoing preventive imprisonment or serving sentence. So, next we have the Republic Act 10592. So, in Republic Act 10592, or the Good Conduct Time Allowances, GCTA laws allow for a reduction of sentence of prison deprived of liberty, depending on how well they abide by rules and regulations inside in any penal institution, the rehabilitation or the detention center, or any other local jails. This law is in relation to Republic Act 7659, death penalty law. Reportedly does not cover with the PDL the person deprived of liberty who have been convicted of heinous crime as enumerated in RA 7659. So this crime were considered punishable by death for being grievous and hateful offense, and which by the reasons of their inherent or manifest wickedness, righteousness, atrocity, and perversity are repugnant and outrageous to the common standard and norms of decency and morality. The application of GTA law resulted to the supposed erroneous release of least 1,914 inmates, a large majority of which already surrendered or returned to government custody at the behest of President Duterte. One's returnee is Antonio Tony Simulata, who was spent close to 30 years in detention, a few months in jail while the murder case was pending, a few months in the Sablayan prison and penal farm, and more than 25 years in a maximum security prison in the National Bilibid prison in Muntinlupa. So next, we have the prohibited acts subject to disciplinary action. So what are these? So the participation in a illegal sexual act, public display of pornography materials, absence, language, and displaying any behavior which might lead to disorder or violence. Position of articles posing a threat to prison security or maligning or insulting any religious belief of group, giving gift, selling or engaging in a barter with anybody, gambling, lottery, rendering personal services to or requiring personal services from inmates, tattooing himself, engaging in business or profession from within. So the self-discipline to achieve its purpose, discipline shall be firm to ensure safety and good order in prison. There are the procedures for handling disciplinary cases. Number 1. So a written complaint shall be filed with the superintendent by the aggrieved inmate or by any inmate or prison personnel having personal knowledge of the incident. The complainant shall sign the complaint and shall describe the violation and name of possible witnesses. Second, the superintendent conduct initial investigation, and if the complaint is found to have basis, shall endorse the case to the Board of Discipline for hearing. The third is the Board of Discipline shall decide on the case within 5 working days after the termination of hearings. The fourth is the hearing is summary in nature and not bound by technical rules of evidence. The fifth is the inmate charged shall be allowed to present evidence in hearing. And the last is decision of Board of Discipline is subject to review the approval by the superintendent whose decision is final. So the disciplinary measures, the question of reprimand, the cancellation of privileges, the deprivation of GCTA, and change of security classification. Next, we have the BGMP, the RA 6975, and Republic Act 9263. As one of the 5 pillars of criminal justice system, the BGMP was created to address growing concern of jail management and penology problem. Primarily, its clients are detainees accused before a court who are temporarily confined in such jails while undergoing investigation, waiting final judgment, and those who are serving sentence promulgated by the court 3 years and below, as provided for under Republic Act number 6975. The Jail Bureau is mandated to take operational and administrative control over all city, district, and municipal jails. So the Bureau has 4 major areas of rehabilitation program namely livelihood programs, the educational and vocational training, the recreation and sport, and religious spiritual activities. These were continuously implemented to eliminate the offender's pattern of criminal behavior and to return them to become law-abiding and productive citizens. Although the workplace of the jail bureau is confined inside the portal of the jail to safeguard person deprived of liberty. Then the bureau has an inherent functions of informing the public of jails operation and other matters concerning the correction pillars of the Philippines. And coincidentally, I mean, coincidentally, being a new and growing bureau, the BGMP aims to keep the public abreast of information regarding jail management and penology. In Republic Act 9263, an act providing for the professionalization of the Bureau of Fire Protection (BFP) and the Bureau of Jail Management and Penology (the BJMP), amending certain provision of Republic Act No. 6975, providing fund thereof and for other purposes. RA 9263 provides the Bureau shall be headed by the chief, who is assisted by two deputy chiefs, one more administration and another for operation, and one chief of directorial staff, all of whom are appointed by the President upon recommendation of the DILG Secretary from among the qualified officers with the rank of at least Senior Superintendent in the BGMP. The Chief of the BGMP carries the rank of Director and services a tour of duty that must not exceed 4 years, unless it's extended by the President in times of war and other national emergencies. Officers who have retired or are within 6 months from their compulsory retirement age are not qualified to be appointed as jail director or designated as BGMP chief. So the basic idea of treatment is to help the criminals enhance their ability to help themselves. They focus specific types of offenders such as sex offenders, violent offender, and drug addicts. There is a notion that rehabilitation program reduce recidivism quite markedly with some types of offenders and some circumstances. It is not surprising to find that some question will be raised. For example, with whom they are implemented and under that what circumstances the program work. To answer this question, we have to analyze the characteristic of the offender and the treatment program in use. Next, we have the privileges of detainees and sentenced prisoners. We have the disciplinary measures. Rights are guaranteed to all prisoners, but access to many prison privileges is based on behavior. Inmates with a history of infractions may be confined to their cell for a longer period of time during the day, or they may be forced to wear prison uniforms, while other inmates can wear their own clothes. Other common privileges include access to entertainment, work, and money. Many prisons have television in common areas, but some inmates have one in their cells and pass the time. Depending on the status of their imprisonment, they may also be allowed to work. Generally, prisoners cannot choose their assignment or refuse an assignment, and the wages they earn for work are well below the minimum wage. Most most work occurs in the prison or jail, though some inmates may be granted work release, which allow them to do work such as trash collection outside the facility. Not all prisoners may be granted the same privileges, or they may be granted a limited privilege. Behavior is often the deciding factor in which prisoners have which privileges. The criminal history and the prison security concern can be factored as well. Unlike privileges, all prisoners are guaranteed the same rights for the term of their incarceration. We have the Regional Rehabilitation Center for Youth. So the RRCY is a facility designed to provide incentive treatment in residential settings for the rehabilitation of CICL whose sentences has been suspended. It serves as nurturing out-of-home placement for the children in need of rehabilitation. Well, in the Regional Rehabilitation Center for Youth provides the institutional rehabilitation for CICL. Community-based rehabilitation program are also being provided by the DSWD. Whenever necessary, the Regional Rehabilitation Center for Youth links its center-based to community-based program or the program provided in the community setting developed for the purpose of intervention and diversion from formal court proceedings as well as rehabilitation of CICL for final reintegration into his family and community. So the support and the participation of the immediate family and community is valuable. Hence, the Regional Rehabilitation Center for Youth, the RRCY, harnesses the community support structure outside of the family. Community structures are mobilized to contribute their resources to the treatment and reintegration of offender and strengthening their families. Their specific objective so that they assess the CICL and gaining insight in their behavior and attitude to help them become a more productive and responsible individuals. They redirect their behavior and attitudes to help them become more productive and responsible individuals. Provide an opportunity to acquire social, occupational skills, and provide improve self-image, and also to provide activities that would help them develop trust for other person. So next we have the Child and Youth Welfare Code. The Presidential Decree number 608, the Child and Youth Welfare Code, Article 1 Declaration of Policy. The child is one of the most important assets of the nations. Every effort shall be exerted to promote his welfare and enhance his opportunities for useful and happy life. The child is not a mere creature of the state, hence his or her individual trait and aptitude should be cultivated to the utmost insofar as they do not conflict with the general welfare. The molding of the character of the child starts at the home. Consequently, every member of the family should strive to make the home a wholesome and a harmonious place, as its atmosphere and condition will greatly influence the child's development. Attachment to the home and strong family ties should be encouraged, but not to extent of making the home isolated and exclusive and unconcerned with the interests of the community and the country. And the Article 1 and so the natural right and duty of parents in the rearing of the child for civic efficiency should receive aid and support of the government. Other institutions like school, church, the guild, the community in general should assess the home and the state in the endeavor to prepare the child for the responsibility of adulthood. So in Article 3, Right of the Child, every child is endowed with the dignity and worth of human being from the moment of his conception as generally accepted and medical parlance and has therefore the right to be born well. Every child has the right to a wholesome family life that will provide him or her with love, care and understanding, guidance and counseling, and moral and material security. Every child has the right to a well-rounded development of his personality to the end that he or she may become a happy, useful, and active member of society. Every child has the right to a balanced diet, adequate clothing, sufficient shelter, proper medical attention, and all the basic physical requirements of a healthy and vigorous life. Every child has the right to be brought up in the atmosphere of morality and rectitude for the enrichment and the strengthening of his character. Every child has the right to an education commensurate with his ability, to the development of his skills, for the improvement of his capacity for service and himself and his fellow men. Every child has the right to full opportunities for safe and wholesome recreation and activities, individual as well as social, for the wholesome use of his leisure hours. Every child has the right to full opportunities for safe and wholesome recreation activities individual. And every child has the right to protection against exploitation, improper influences, hazard and other conditions or circumstances prejudicial to his physical, mental, emotional, social, and moral development. Every child has the right to live in a community and a society that can offer him an environment free from pernicious influence and conducive to the promotion of his health and the cultivation of his desirable traits and attributes. Every child has the right to the care, assistance, and protection of the states, particularly when his parents or guardians fail or unable to provide him with the fundamental needs for growth, development, and improvement. Every child has the right to an efficient and honest government that will depend in his faith in democracy and inspire him with the morality of the constituted authorities both in their public and private lives. And last is every child has the right to grow up and free individual in an atmosphere of space, understanding, tolerance, and universal brotherhood, and with the determination to contribute his share in the building of a better world. Next, we have the death row and the rule on the writ of amparo. The Philippine House Bill 7814, the adoption of bill allowing the imposition of the death penalty for from a new crime. Adoption of bill it is adopted on March 2nd, 2021. This bill comes after years of President Rodrigo Duterte unflagging insistence to reintroduce the death penalty to the Philippines. Despite the country having abolished the capital punishment for all crimes in 2006. The Philippine House Bill No. 7814. This bill comes after years. So the reintroduction of the death penalty. The passage of House Bill No. 7814 is an attempt on the part of the government of the Philippines to reintroduce the death penalty who under at strengthening the country drug prevention and control. Section 20 of the bill provides a mandatory penalty of death for a new crime involving the use of implementation of a search warrant based on prejudice or falsified document or planted evidence. There is also the presumption of guilt if the accused planter does not follow the investigation procedure under Section 19 of the bill. Not only do this provision demonstrate intent for a broader introduction of death penalty in the Philippines, but they prevent human rights institutions in the country from carrying out effective work. The reintroduction of death penalty will create more problems, particularly in terms of livelihood that may be lost given the dire economic situation, especially of the disadvantaged, marginalized, and vulnerable sector of society. It emphasizes that many industries, much especially the agriculture sector, have benefited tremendously under this trade agreement. The CHR in the Philippines also noted in the statement that they are ready to work with the government to craft human rights and evidence-based policies to assure the right of the accused and affirm the universal right to life, providing for the presumptions of guilt. The bill is questioned would additionally provide for the presumptions of guilt for people accused of trafficking crimes and involving with illegal drugs. The system of law, the Philippines adhere to the basic tenet that presumes a person innocent until proven guilty. This element of Bill No. 7814 emphasizes further a danger of reintroducing capital punishment. The death penalty is an irreversible sentence, and no justice system is free from judicial errors. The presumptions of guilt provision compromises a person's right to due process. With this bill, there is an increased risk of an irrevocable miscarriage of justice. So, in the death row of a Philippine Bill No. 7814, adoption of bill allowing the imposition of the death penalty of a new crime. It's adopted on March 2nd, 2021. Next, we have the rule of the writ of amparo. The petition for a writ of amparo is remedy available to any person whose right to life, liberty, and security is violated or threatened with a violation by unlawful or act of omission by the public official or employees or on a private individuals or entity who use the writ of amparo. Section 1, the petition. The petition for writ of amparo is remedy available to any person whose right to life, liberty, and security is violated or threatened with violation of the unlawful act or omission of a public official or employees or of a private individual or entity. Why is it called the writ of amparo? Amparo means protection, while both writs were convicted to solve the extensive Philippine extrajudicial killings and forced disappearance since 1999. So why is the writ of amparo is important? The right of amparo is a legal procedure to protect human rights Under this new legal remedy, state authorities can no longer use of defense that they do not know where the missing a person are, how the writ temporo is served. As we can see in the petition 1, the writ how it's served. So the writ shall be served upon the responded by the judicial officers of a person deputized by the court, justice and judge, who shall retain a copy and which to make a return of service in the case of written cannot be served personally to the respondent. The rule on substituted service shall apply. So as we can see, we have the to discuss the BJMP RA 6975 and Republic Act 6263. So in one of one of the 5 pillars of the criminal justice system, the BJMP was created addressing a growing concern of jail management and penology problem. As provided from under RA No 6975, the Jail Bureau is mandated to take operational administrative control over all the city, district, and municipal jail. So, what the Republic Act 10592, it is the good conduct and allowance allow for a reduction of sentence of person deprived of liberty, depending on how will they abide by rules and regulation inside in any penal institution, rehabilitation, or detention center of any other local jail. Take note that in Republic Act No 10592, Section 3, Article 29 of Act Number 3815, as amended, otherwise known as the Revised Penal Code, is hereby further amended. So the allowance for good conduct and the Section 4 of the RA 10575. Under it is the section for the mandates of the Bureau of Correction, the program. So the reformation of national inmates, the reformation program which will be instituted by the Bureau for the inmate shall be the following. The first, we have the moral and spiritual program, the educational and training program, the work and livelihood program, the health and welfare program, and the behavior modification program, and include therapeutic community. So in the structure, the Philippines correction system is composed of the institutions in the government, civil society, and the business sector which are involved in the confinement, correction, and restoration of this individual charge of the convicted and also the delinquent act of crime. Despite of a prison overpopulation, a lack of information technology system and knowledge, inadequate training, the Philippine government continues to take meaningful measures toward improving prison and jail facilities and offender treatment. However, the correctional system reform and convicts' effective reintegration into mainstream society are not just the duty of correction system. They require the support and participation of the whole society. In the correction and rehabilitations of criminals, the government plays a dominating and vital role. So, the regulation of correction facilities are intended to allow convicts to form a personal and social relationship. Control over the nation jails was improved because of the consolidated jail system. Also, we have the special program and a 4 residential institution offering assistance of youth development and special needs youth. Several task forces and committees have advocated improvement, such as the creation of national agency to oversee all penal facilities, a more liberal system release and recognizance and legalization of victimless crimes. So in the Philippine government correction system is so we have the 6 the one 2, 3, 4, 1, 2, 4, 5, 6. So the two base system-based approaches, the correction, the institution-based approach, the community-based approach. So in the community-based approach, they seek to provide the community as they complete their sentences. These programs typically enable criminals to work and attend schools while incarcerated and either placed in parole or given probation. So we have the three departments of the executive branch of government: the Department of Justice, the Department of Interior and Local Government, and we have the Department of Social Welfare. And next we have the Bureau of the Corrections, RA 10575, Safe Game of Inmates. We have the Good Conduct Time Allowances, Republic Act 10592, the Program and Services, and the prohibited acts subject to the disciplinary. So remember that participating in illegal acts, public display of pornography, material, substance, language, and displaying any behavior which might lead to disorder or violence. Possession of article possessing a threat to person, security, or insulting any religious belief or group, giving gifts, selling, or engaging in a barter with anybody, tattooing himself, engaging in a business or profession from within. So we have the decision of the board of discipline is subject to review the approval of the superintendent, who's its final. So we have for the disciplinary measures: caution of reprimand, cancellation of privileges, deprivation of GCTA, and change of the security classification. The BJP RA 6975 and the Republic Act 9263. So in Republic, as provided under the RA No 6975, the Bureau was 4 areas of rehabilitation program. So namely livelihood program, educated vocational training, the recreation and sports, the religious and spiritual activities. These were continuously implemented to eliminate the offenders' pattern in criminal behavior and to reform them to become law-abiding and productive citizens. And Republic Act 9263, the act providing for the professionalization of the Bureau of Fire Protection, BFP, and the Bureau of Jail Management and Penology. The BJMP amending certain provision of the Republic Act No 6975, providing funds thereof of another purposes. So the RA 9263 is provides that the Bureau shall be headed by the chief, who is assisted by 2 deputy chief, 1 for administration and other operation, and 1 chief directorial staff, all of whom appointed by the President upon recommendation of Department of Interior and Local Government Secretary, from among the qualified officer with the rank of least senior superintendent in the BGMP. We have the privileges of the detainees and the sentenced prisoners. The disciplinary measures: right to granted all prisoner but access to many prison privileges is based on the behavior. Inmates with a history of infractions may be confined in their cells for longer period of time during the day. They may be forced to wear prison uniform, while other inmates can wear their own clothes. So we have the Regional Rehabilitation Center for Youth that I have discussed earlier, and their specific objective: redirect their behavior and attitudes to help them become more productive and responsible individual, provide opportunity to acquire social occupational skills, and improve self-image. Also to provide develop trust for other person. So we have the Child of the Youth Welfare Code. Take note that Presidential Decree number 603, the Child and Youth Welfare Code. That was then we have the right of the child, and the death row and the role of the right of amparo. That's could be all. Thank you for listening.